Good afternoon, and on behalf of CBIA, thank you for joining us on this discussion of managing medical leaves of absence. The recent changes to the FMLA statutes have resulted in companies throughout Connecticut looking for additional guidance on this topic. Questions pertaining to this issue always account for a high percentage of the questions Diane McCrisky and I get through the HR hotline each week. Fortunately, we are pleased to have with us Nick Zaino and Vincent Farisello, partners of the law firm Carmody Torrance Sandak Hennessey, to help us on these issues. Nick Zaino is a partner and co-practice group leader of the firm's business and personal services group and has practiced in this area for over 20 years. Vincent Farisello is also a partner with Carmody and Torrance and also practices in the area of labor and employment and general corporate law. As I mentioned before, the Q&A format allows you to ask your specific questions. We encourage you to use the Q&A feature that just facilitates, makes it easier for us to answer your questions. Again, thank you for joining us today. Our first question has to do with the laws which make up the area which are covered by the areas of medical leave absences. I'm not sure which Nick or Vincent, which one of you would like to take it, but what laws generally come into play when we are talking about medical leave absences?
I'm happy to jump in on that one. Generally, there's 5 key statutory schemes that come into place when we're talking about medical leaves of absence. The first is FMLA, Family and Medical Leave Act, and as most folks know, there is both a federal statute and a state statute, and I'm sure we're going to get into the specifics of both of those as we go on, but the key point here is that the state one was recently amended. There's now a pay component to it. And one of the key amendments was that it drastically reduced the threshold of companies that are covered by that law from 75 down to just 1. And so practically all employers in the state are covered by the state FMLA. And just in the broadest brush strokes, what the both federal and state FMLA, what they do is generally provide job protected leave to covered employees for certain covered absences. And those could include the employee's own serious health condition, if they need to care for certain relatives, serious health conditions, and then also for a couple other miscellaneous reasons. The second bucket of statutes are also have a federal and state component, and those are the disability discrimination laws. On the federal side, there's the Americans with Disabilities Act. On the state side, there is the Connecticut Fair Employment Practices Act. And in a nutshell, both of those statutes essentially protect employers and also job applicants from discrimination on the basis of their disability. But they also require employers to engage in an interactive process with employees who may have disabilities and who, with some reasonable accommodation, can continue to perform the essential functions of the job. The third kind of bucket, again, has a federal and state component but in a much more narrow scope, and that includes pregnancy, pregnancy discrimination laws. There's a federal and state version of those, and under that scheme, a female who may be pregnant is entitled to, again, a non-discrimination on the basis of her pregnancy, but also in certain contexts, some reasonable period of time off from work. In Connecticut, we also have a paid sick leave law that currently applies to employers with 50 or more employees. So if you're out there over that threshold, that's another statutory scheme that you need to be mindful of when you're talking about employee medical issues. And then fifth is Connecticut's workers' compensation statute. Simply put, that law provides for payment of compensation and rehabilitation for injuries or illnesses that arise out of or during the course of employment. So you have these 5 buckets of statutory requirements, and it's, the reality is not every situation falls neatly into just one of them. A lot of times there is required coordination between the two, they overlap. And so, having a good handle, it's a good place to start by the way we just did, by going into the nutshell requirements of all of them. But, like I said, there are plenty of situations where a circumstance can implicate more than one of those statutory schemes all at the same time.
Yeah, and I always try to keep those statutes in mind. Whenever you have a medical leave of absence situation, you always want to have at least a mental checklist of which statutes might apply. And sometimes it's just one, and sometimes it's more than one, and sometimes they overlap and sometimes they don't. So if you were drawing, if you had concentric circles, all these different statutes would probably overlap in various spots. And so, and the first question we have kind of addresses that particular issue. So under the Connecticut Family and Medical Leave Act, it's actually not effective until July 1st, but the statute says that effective July 1, and then annually, you have to provide written notice to each employee of their entitlement to FMLA. And there's certain things in the statute, the opportunity to file for benefits with the paid FMLA authority, and that retaliation is prohibited, and that individuals who feel they've been retaliated against may file a complaint with the labor commissioner. That notice requirement kicks in July 1st under the Connecticut Family and Medical Leave Act and the paid FMLA. There are forms that you can use for that the FMLA has put out. And under the federal FMLA, if you have a handbook, if you're covered, which Vincent had said it's 50 or more employees under the federal FMLA, if you have a handbook, you really do need to have a handbook policy that identifies what the rules, what your policies are concerning family and medical leave.
Just to piggyback on that, Nick, I don't think that there's the same way there's a requirement to have the policy under the state one.
Right.
But, I've found, the clients I'm working with, I find it in most cases to be advantageous, even if you're only covered by the state, to have a policy, because there are plenty of things that an employer gets to choose about the administration of FMLA. And so I think it's a good idea to have that in a policy. It helps ensure consistency, but it also keeps employees from guessing, because some of those standard form notice things from the state are not going to have the specifics about, certain things that the employer can choose. For example, how the employer is going to measure the 12-month period for which 12 weeks are available.
No, I totally agree. I completely agree, Vince. The same is true with the forms that you use to administer FMLA leaves. The federal DOL had for years issued forms that employers could use to administer FMLA, like a medical certification form, a notice of rights and responsibilities, a designation notice. You're not required to use those forms, but they're very helpful. And now the state of Connecticut has also adopted similar forms as well. And so I think those forms are helpful for employers to use in administering FMLA leave. So I agree with that.
We have a couple of questions in the chat.
If we do, you mentioned the bucket, and there's one that speaks to the number of various buckets as far as the different laws. And we have a question in regards to the paid FMLA as far as the number of employee requirement.
Yeah, I think there was maybe some misunderstanding about what I had said. The Connecticut FMLA and the paid leave portion applies pretty much to all employers in the state. The threshold of 50 or more employees for state law, that's with regard to Connecticut's paid sick leave law, which was in existence since about 2011, I think. And that's the law that requires up to covered employers, again, those with 50 or more employees, to provide certain minimum paid sick leave benefits to their service workers, not to all employees, but just to employees that fall under the definition of service workers. And that's the law that requires for those people to earn at a minimum of 1 hour for every 40 hours worked, capped at 40 hours of paid sick leave per year. So I think there was just mixing up the Connecticut paid sick leave law versus the Connecticut paid FMLA. They are two separate things.
Fair enough. How you work the paid time off, it seems to be a common theme. We have another question that speaks to when a company has separate sick and vacation buckets, how does the PTO bucket relate to the CTFMLA, given the requirement that you have to have the employee keep 80 hours off their PTO time?
So I was actually looking at, there's an FAQ on point at the Paid Leave Authority website. And I'm looking at the current iteration of that FAQ. The FAQ is my employer required to pay me when I take CTFMLA leave? I'm going to briefly say what the answer is from the FAQ, and then talk about how I think that might have changed over time. But the answer is generally Connecticut FMLA leave is unpaid. However, an employee's accrued paid leave with the employer, such as vacation, sick leave, personal leave, or paid time off, may be applied to the leave if required by the employer or requested by the employee. An employee, however, may choose to preserve up to 2 weeks of their accrued paid leave time. So I think that the general obligation is to allow the employee to keep up to 2 weeks of any of the paid leave. If you're out there with a single bucket PTO policy, that means allowing the employee to choose if they want to keep up to 2 weeks of that PTO time. If you have separate buckets, the way this FAQ reads now does not seem to distinguish between sick leave, personal leave, or vacation. And so I think the way I interpret this is that as long as there's 2 weeks of paid time off at all, it doesn't matter out of which buckets it comes from. I think this has changed a little bit because I vaguely remember months ago, this policy in my mind seemed to imply that the employee had to be, that it was the personal or vacation or PTO that would have to be reserved, up to 2 weeks of which would have to be reserved. Didn't seem to be the case with the sick time, but the way this reads now, I think that it's 80 hours of any, if you have multiple buckets, or the PTO if you have a single bucket.
Okay. If we could just quickly go back to something you said earlier as far as the sick leave law. Someone asked us if you could define what is a service worker.
Yeah, it's interesting. It's actually a list that has changed a little bit over time, but not too much. It's a list of about 68 or 69 different, I believe they're not NAICS. It's based on one of the Bureau of Labor Statistics assigns numbers to each different type of occupation. And so it's actually a list that, again, that's changed over time, but it's not like a general definition. It's any position that falls in this list of 68 to 69 job codes. And so if you take a look at the CTDOL website, it actually has that listed there along with what the BLS codes that relate to the title are.
Yeah. Earlier, I believe it was you, Nick, you mentioned that as of 7/1, there are certain posting obligations that the employer will have for the employees. It was my understanding that the DOL would post these by the beginning of the month. Are they available as yet, to your best of your knowledge, or?
You know, I can't tell. I'm looking on the website now, trying to find that answer as we speak. I know the Paid Leave Authority put out a very simple one-page kind of poster that employers were urged or encouraged to use to notify employees of their right to take FMLA leave. You know, I think you can go back and look at that one pager and see if it satisfies the specific notice requirement in the statute that's effective July 1st. So again, that notice, one, you have to tell employees of what they're entitled to take. Two, that they have an opportunity to file for benefits with the FMLA authority. I'm not sure if that one-page notice covers points 3 and 4, that retaliation by the employer, is prohibited, and that folks can file a complaint with the labor commissioner if they feel that they have been retaliated against. What's a little peculiar about the notice obligation is it says each employer shall do that at the time of hiring and then annually thereafter. And so what I'm hopeful, there will be some guidance on what that means annually thereafter. Is that a specific notice that goes out to every employee every year that identifies, these various points, or is a policy that's in the handbook where employees can look at that policy at any point? Is that sufficient to meet that notice requirement? So I haven't seen specific guidance on that yet, but hopefully it's the latter, where you just simply have a policy that covers those points and not an actual annual notice that goes out, physically goes out each year.
Just to follow up on the last question I had, I did just post to the chat for everyone's benefit the link to the CTDOL page on sick leave. And there's a link there to the statute, which in the statute has the listing of the service workers that are covered by the paid sick leave law.
One of the more common concerns that employers will call Diane and myself about is when they feel employees are possibly taking advantage of the law. We have a question that speaks to when an employee uses the maximum of their 12 weeks within the 12 months, can the employee then terminate employment, or does the employee, if the employee fails to return? How do you suggest that should be handled?
Yeah, so we get this question all the time, and it's frustrating because, when Vincent spoke about which laws come into play, you mentioned the Family Medical Leave Act, certainly, and also mentioned the ADA and Connecticut Fair Employment Practices Act, which is similar to the ADA. And, while the rules are fairly bright and clear under the Family Medical Leave Act, right, it's 12 weeks of job protected leave, we always have to think about the ADA and the Connecticut Fair Employment Practices Act, which require employers to provide reasonable accommodations for employees who have a disability. And the federal and state courts have held that a leave of absence can be a form of a reasonable accommodation. And so, even though FMLA has clear rules, 12 weeks, job protected leave, if somebody needs additional time off because of a disability, the EEOC, the CHRO, federal and state courts would expect employers to explore that additional leave and whether or not the employer can provide it as a reasonable accommodation. And on that, nobody can give you a bright line answer on what that is and when that obligation ends. It's just based on a case-by-case scenario as to how much additional time is the employer requesting? What's their job? Do you have other individuals who can fill in those job duties? Can you fill those job duties through a temp agency? And a whole other host of criteria for you to go through in determining whether or not additional time off from work might be required under these disability leave laws. And so, it's pretty clear that if somebody requests an indefinite leave of absence, that is not a reasonable accommodation. But typically what we've seen is that an employee may request an additional 2 weeks once FMLA ends, and then request an additional 2 weeks on top of that, and then maybe an additional week. And, at some point, the employer is going to say, we can't continue to accommodate, this additional time off. We really do need to fill this position. Attendance is an essential job functions. And, the more generous, I guess, the employer is, the more the pendulum swings in favor of the employer. But really, it's really not a bright line answer. It's really on a case-by-case basis.
Fair enough.
Yeah.
Coming back to the paid leave, if a holiday falls during the time when the employee is on the paid leave, can the employer not pay for the holiday?
Yeah, so it's funny, I just had this issue come up recently, and I think you have to go back and look at your holiday policy and what it says. Practically speaking, in my experience, the holiday will continue to be honored and not counted as FMLA. So for that particular week, the employer generally would exclude the holiday from FMLA. But you got to go back and look at your holiday policy to determine what you say with respect to paid holidays. Some employers have a policy that says you must work the day before and the day after the holiday in order to be eligible for holiday pay, period, right? In which case you can perhaps take the position that, that is not going to be a paid holiday. It will be an FMLA day. We're not going to pay you. You get whatever you get under the FMLA, pay schedule. Some employers write it to say you get holiday pay if you must work the day before and the day after the holiday, unless it's an excused absence, in which case an FMLA would be, and the employee would likely get the holiday pay. So I think it reverts back to what the employer has in its policy.
Fair enough. The poster issue comes up again, and just to clarify, is this a physical poster that one must post, or can you refer the employee to your handbook?
This is probably a reference back to the July 1st notice requirement.
Yes, I'm sorry, yes.
Yeah, I mean, just looking at the statute, it says written notice to each employee. And so it doesn't say it's a posting. It doesn't say that it's something that you could cover necessarily in the employee handbook. And so, I would hope that we would get some guidance on what exactly that means. Written notice shall provide written notice to each employee, right? And so I think it's still an open question as to whether or not a posting in the workplace or a policy in the handbook or a memo that has to go out to each employee is sufficient. I would hope that a posting or a policy in the handbook would be sufficient, but just not clear based on the wording in the statute.
Fair enough.
I saw a question that I think we didn't get to before. I don't think. It says, what if an employee has used all or most of their PTO time and then goes on Connecticut paid leave so that there is not 80 hours of PTO left? So I think that if at the time someone goes out on FMLA leave, if they have no PTO left, there's no PTO left for them to reserve. If they have less than 80 and they want to keep that, they certainly can. They also can elect to use it if they want, but there's no obligation that the employer provide some additional PTO that doesn't exist or hasn't already been accrued.
Another topic that comes up when members call has to do with the interplay of STD and the new leave policy. And one of the individuals were asking, have you seen employers change their STD plans because of the new laws?
So I'm going to answer generally, and I know, Nick, you've done some stuff very recently on some of these, but what I've seen is because there tends to be so much overlap with FMLA claims and STD benefits, particularly when it's, or frankly, only when it's when the FMLA leave has to do with the employee's own serious health condition. What I've seen is a lot of the STD policies have been changed or have been modified so that to the extent there's overlap with paid leave benefits from the state, those will offset the benefits from the STD policy. The good point about that is when that's happening, that's often, I've seen that's resulted in some reduced STD premium rates for employers who've done that. But that's kind of what I've seen the most. Nick, I know you've dealt with this pretty recently.
Yeah, no, I think you got it right, Vince. I mean, I think the initial question employers were asking is, should we even continue STD policies? And, Guy, I think just based on our experience, we haven't found that employers are necessarily dropping their STD policies, but they are coordinating pay and benefits. And so, as Vince said, if you have an STD policy, whether it's self-insured or fully insured, you do want to take a look at the language and see what happens when somebody applies for FMLA benefits and at the same time is entitled to STD. And we've seen policies be amended to reflect that the STD benefit is offset by what you get or what you're eligible to get in FMLA benefits, because somebody may choose not to apply for FMLA benefits.
Just to quickly clarify, when we say STD, we were talking about short-term disability
Yes, sorry, yes.
policies. That's caller inquiring. The next question, when an employee exhausts their FMLA and you continue to extend under ADA, can you count that time against the FMLA so the FMLA 12 weeks doesn't reset?
It's a clever question, but the answer is no. It's 12 weeks over whatever the 12-month period that's been defined by the employer. So whenever that 12-month period expires, it essentially resets and the employee is entitled to another 12 weeks. I think that's the answer there.
Okay. Coming back to the STD issue, I'm sorry, the person's want to clarify, so there's no formal provision for FMLA extension.
No, when the FMLA ends, so here's what we would suggest, because this comes up a lot. I mean, this is a common question that employers ask about, do we have to provide additional time beyond FMLA? And so the short answer is maybe. It depends on the circumstances. It depends on the ADA, the Connecticut Fair Employment Practices Act, and whether it's an undue hardship and so on. But we generally talk about a strategy for managing leaves, and there is not the answer to the question simply, there's no formal provision for an FMLA extension. Once FMLA ends, you've completed your obligation to provide leave under the Family Medical Leave Act, and now you're in the interactive process that's envisioned by the ADA with the employee about, okay, well, how much more time do you need? When will you be back to work? That sort of thing. What we generally suggest as a good practice is you communicate with your employees when they're on FMLA, right? While they're on FMLA, as they're getting closer to that return to work date or the expiration of their FMLA, that employers stay in touch, not in a harassing way, but simply remind employees that they're due back at work, on X date, either because that's the date their need for FMLA leave ends or the date that their FMLA expires. And then the employee may write back and say, well, I don't know that I'll be back that day. My doctor suggests that I may need more time, and that the employer continue to engage in that discussion even before the FMLA period ends. Why do you do that? You do that to show, one, that you do need that employee back, like you are relying on that employee's return to fill that position to run your business, and that it matters. It matters that they return on that date when FMLA ends or when their FMLA expires. It also shows that you're engaging in the interactive process. And so when that employee says to you, I need more time than what the FMLA allows, you then are naturally ongoing, have this ongoing discussion. And you can ask for doctor's notes, you can ask how long, you can talk about, the need to fill the position, and at some point the employer may very well just make that decision, I just cannot continue to accommodate leaves beyond this particular period of time.
With that in mind, there's a question as to, well, what is the time frame that we use to designate the leave? And it reads as follows: the employer defined 12-week period. Can the employer define a 12-month clock to start on day one of an FMLA leave? So it's a rolling period, and the employee is not locked into a calendar year? Or what is your suggestion as far as the best method to use of the three possibilities, calendar year, rolling year, or looking backward?
So this is one of those areas where the employer does get to make a choice, and the employer can choose what that 12-month period is, and it can be a fixed period, whether that be on a calendar year basis, a fiscal year basis, or it can be on a rolling period, a rolling basis, and that could be rolling a 12-month rolling look back or a rolling 12-month look forward period. So the answer is the employer does get to choose. They're not stuck with any specific fixed period. So if you have a policy, that's one of the places where you would where that would be where you would give notice of that. Our general recommendation has been to use the rolling period, and part of that came from some concern that when you use a fixed period, the leaves can get stacked. For example, let's say you're using a calendar year basis, just for example, and someone uses the last 12 weeks of one calendar year, they might be entitled to the first 12 weeks of the subsequent one. So they've turned their 12-week entitlement into essentially 24 weeks of continuous covered protected FMLA leave. So for that reason, that's one of the reasons why we generally recommend the rolling basis.
If I could, maybe you could add to that. One of the frequent suggestions from members is that they prefer the calendar choice for administrative purposes. It's easy to explain. It's convenient to record. Given what you've just said, could you add pros and cons in the calendar?
I think the pro is just what you said. It's ease of administration. It's easy. People really understand it. And I think the biggest con is the one that I mentioned, which is that it's, you know, it's susceptible to be, you know, there's that risk of being able to stack 2 years worth of entitlement in one continuous leave. I think that's the biggest con.
Does the burden still lie on the employer to notify the employee of leave rights?
So the answer to that is yes. The employee does not specifically need to reference the FMLA. The employee does not have to apply for the FMLA. The employee only needs to give, in order to trigger their right under the FMLA, only needs to give the employer enough information for the employer to conclude that FMLA may apply. And so, you know, once the employee does that, you know, I have surgery scheduled for Monday. I think I'm going to be out all of next week and maybe into the following week, right? Something like that. That contemplates time off from work for more than, you know, 4 days or more. At that point, that could very well be leave under the Family Medical Leave Act. And so the employer at that point would have an obligation to talk to the employee about FMLA, about their right to take FMLA, and should begin the process for designating that leave as FMLA, because whether the employer designates it or not, if it would otherwise constitute FMLA leave, regardless of the paperwork, regardless of whether the employer formally called it FMLA, it is FMLA job protected, right? And so by not designating it, the employer may not be able to go back and retroactively count it against an employee's 12-week entitlement, yet that leave would still be protected. And so the employer, one, has a legal obligation to talk about FMLA when it sounds like it's FMLA or could be FMLA, and the employer should do it anyway. Otherwise, it's job protected and they may not be able to retroactively go back and designate it as FMLA.
That kind of dovetails right to sort of the question that follows right after that, which is, can you shed any light into the start of an FMLA leave? I've heard different answer as to when the clock starts, when the first day of the reason starts, or when the certification is turned in. How does that play into an employer designating a leave without having the actual certification in hand?
Yeah, so it starts when the leave starts. So even though you don't get the MedCert form back, and it may take you 15 days, right? The statute says they're supposed to turn the MedCert form in within 15 days, but it could take longer than that, practically speaking. But if the person went out, you know, on May 1st and they requested leave and you began the process and they didn't actually submit the MedCert form until May 15th, the leave begins May 1st. And so you'd go back from the first date of leave. You know, the one other question we often get, which is a bit of a which is a related question, is can the employee say, I don't want to take FMLA leave? No, don't designate it. You know, I don't want to use up my FMLA time. I need this medical leave. It's going to be 2 weeks, but I don't want to use FMLA. And the short answer to that is no. The employer designates the leave as FMLA when it qualifies for FMLA. And so if it qualifies, you know, the employer should count it as FMLA again and deduct that time from the 12-week entitlement. It is the employer's responsibility to do that. And the employee cannot sort of waive it and say, don't count it. If the employer then doesn't count it, it's still job protected because it would be FMLA. And then they may not be able to go back. The employer may not be able to go back later and retroactively designate it.
Yeah, the upshot there is the employee would still have 12 weeks, 12,
Right.
12 other weeks of a job protected FMLA leave in their back pocket. I'm just going to hit another question because I think it's also based on a slight misunderstanding. But if I'm understanding this correctly, an employee could start out taking 12 weeks of paid leave, and if still needed, could take another 12 weeks of CTFMLA, and if unused, still take his 2-week PTO hours before the year end. Yes, no, not necessarily. So the way you have to think of Connecticut's FMLA program scheme, statutory scheme, as two distinct benefits, but that generally will work together. One is the entitlement to up to 12 weeks of job protected leave. That's it, just 12 weeks job protected leave. That's an issue between the employee and the employer because the employer kind of determines whether or not the employee is eligible and whether or not the leave is qualified. And if they're entitled to covered FMLA leave, then they may be entitled to pay benefits, paid leave benefits, it's just the pay benefit from the state. In most cases, those two things will be happening at the same time. So the pay benefit from the state is not the leave itself. There's only ever 12 weeks of job protected leave that's available under Connecticut's FMLA, and that's provided by the employer. Should the employee choose, they can go to the state to seek pay benefits for that 12 weeks of leave. But the employee doesn't have to do that. They could, and if they don't do that, then they may still be entitled from the state for 12 weeks of pay benefits, but I can't imagine they'd be able to use it unless they become qualified, eligible again for job protected FMLA leave, or if they separate from the employer and are not able to work because of an otherwise FMLA qualifying reason, because the paid leave benefits from the state can apply to someone who's unemployed at the time. So no, it's not, they're not two different 12-week leaves. It's just one.
Part of the employee notification question has to do, interestingly, has to do with any potential termination proceedings. The employee is being written up and they conveniently, or so to speak, indicate, well, gee, I need a FMLA leave. How do you suggest that be handled?
Yeah, so I think the write-up for performance reasons, let's say, or for misconduct stands, and that should still be delivered to the employee, as long as there's a legitimate basis for that written warning, the suspension, whatever it is that the employee is being written up for. And then if the employee says, I need to take leave, it begins that process. And it certainly sounds very suspicious when somebody says that in the context of receiving a warning or a disciplinary notice, but the employer can't just dismiss that. You've got to go through and say, go through the process and request a medical certification form and see what that, whether or not that qualifies for FMLA leave.
Does the health insurance, should that be continued, or does that be continued during the leave?
So this is a good question. And everybody knows that under the federal, or should know, under the federal FMLA, yes, there is a requirement under the federal FMLA that an employer continue an employee's health insurance on the same terms and conditions as the employer would if the employee were actively employed. Okay, and that's for all FMLA leaves. Connecticut FMLA does not have that same specific requirement that the federal FMLA has. In other words, Connecticut doesn't say in the FMLA Act itself that the employer must continue health insurance coverage. However, there is an insurance statute in a totally different part of the general statutes, not having to do with FMLA at all, that says to insurance companies, basically, that if you write insurance in Connecticut, you cover employers in Connecticut, you write a policy that covers employers in Connecticut, that policy must allow the employee who is absent from work because of their own illness or injury, the opportunity to continue health insurance coverage for up to 12 months. And if they're actively employed, the policy can have language that says that the employee must continue to pay his or her share of the premiums, just as if they were actively employed. And then upon separation of employment, if the employer ultimately terminates employment, the employer can require that the employee pay 102%. So under a totally different statute, the insurance, regulating insurance, it says that policies must include that language. What I would suggest you all do is make sure you're familiar with the language in your insurance policy about what it says with respect to employees who are absent from work due to an illness or injury, their own illness or injury. So the short answer is if they're out for their own illness or injury and they're still your employee, you do have to continue health insurance coverage as if they were currently employed.
And there's no exception for non-public union laborers? It's for all workers, is that correct?
Correct. The only exception, I think, under that insurance statute, Phil, would be for if you're self-insured, because the statute only regulates self-insured for health insurance. The statute only regulates insurance companies, policies written by insurance companies in Connecticut.
Coming back to the time period, could you go into a little bit more detail as to how the rolling back and rolling forward methods work?
Sure. So the rolling period measured forward is essentially, you look from when the employee requests the leave, looking forward 12 months, that would kick off the 12-month period. So their 12-month period would begin with when their leave starts. And so they would be entitled to, so if that's, for example, on June 1st, if I put in a request for FMLA today to start on June 1 to May 31st would be my FMLA year. That's the rolling forward period. The rolling period measured backward is, you essentially take any period of time that the employee is out, you look backwards 12 months, and you did, and any FMLA leave that they've used in the prior 12 months is essentially deducted from the 12 weeks. So just use an example. If I'm going out on an FMLA leave today, my employer would look back 12 months. And if I used any, let's say in December or January, I had used 3 weeks of time, then I'm entitled to 9 months, 9 weeks left of FMLA time.
Fair enough. Who chooses whether the employee takes CTFMLA or paid leave? Does it defer to company policy or is it the employee's choice?
Well, I think on the FMLA, the job protected leave component, this goes back to what Nick was saying. It's the employer's obligation to designate leave that should be covered by FMLA as FMLA covered leave. That's the employer's obligation to do that. The employee needs to cooperate with any reasonable requests from the employer to make that determination, including, for example, completing and returning the appropriate certification forms. On the pay benefit piece, this goes back to what I was saying, which is that that works in parallel with the job protected leave, but that's ultimately between the employee and the state. And no one can force the employee to go seek that pay benefit from the state. They can if they want to, they don't have to if they don't want to.
The 15-day requirement for the employee to get the forms back, is that 15 calendar days or 15 business days?
I'm pretty sure it's just 15 days from the date the employer gives the employee the medical certification form. See, that's where it's helpful. If you do utilize the forms, the federal DOL FMLA forms, and if you're covered under Connecticut, the Connecticut FMLA forms, to administer that, because those forms both point out that the employee has 15 days to get them back, to get the medical certification form back.
And I think you touched on this earlier, but just to reiterate, the question is, what if an employee says that they do not wish to take the FMLA leave and will use their paid time off to cover their absence? Is this their choice?
So again, if the leave is covered, it's the employer's obligation to designate it. Even if the employee, so if we know, for example, that the leave is covered, we can, as the employer, can choose to designate that leave as FMLA leave, even if the employee does not want the employer to do it. And then whether or not the employee, and so then if the employee chooses not to go get wage replacement benefits, the paid leave benefits from the state, they don't have to, but the employer's policy will then dictate whether or not they're required or allowed to use up PTO time during that leave.
This is on line with the paid leave. If the employee gets denied CPL and we haven't used the employee's PTO, can we, because we want to wait to see what happened if they were approved or denied, can we then take the PTO retroactively?
If an employee gets denied.
So I think if the question is the employee gets denied paid leave benefits, and it could be for any reason. It might be because at their last employer, they already used up their 12 weeks worth of paid leave benefits. And the employer had not begun paying PTO while during that interim period. If the employer's policy is that we require use of PTO for any unpaid portion of leave, then yes, absolutely, the employer can pay that PTO benefit retroactively.
Okay. What happens if you do not get the medical certification back after 15 days?
So I think go ahead, Nick. Go ahead.
No, I mean, I think that that also comes up with some frequency too. You know, you kind of need to, I think you need to find out why it's taking more than 15 days. And sometimes it's truly the fault of the medical provider. I mean, the obligation is on the employee to ensure that their healthcare provider gets that form completed and returned to you as the employer within 15 days. The regulations do say that if they don't send you back a completed medical certification form, you can deny the leave or not count it as job protected FMLA leave. But we're always very careful about that. We want to make sure that you go above and beyond to give the employee every opportunity to get that medical certification form returned, promptly and completed in a proper way. Like, we don't like, sort of technicalities, but there are definitely times when the employee is just not cooperating. And in those circumstances, the employer has the right to say, well, we're not going to count it as FMLA leave because we're not certain it in fact qualifies as FMLA leave. We don't have the medical certification form.
And one caveat to that too, the ability for the employer to ask for the med cert form is really the employer's choice. It's a tool you can use to help you determine whether it qualifies. It's not necessary. An employer could still designate leave without a med cert form, because I've had plenty of circumstances where the employer knows full well what an employee is going through health-wise, medically, whatever, and doesn't really need that med cert form to make that determination. I've also had circumstances where sort of a non-cooperative employee situation where even though we never got, even though the med cert didn't come back, granted some leave anyway, designated it anyway, depending on the facts and circumstances, it might make sense to do that anyway. But the overall point though is that you don't really need the med cert form. It's a good tool to use.
Yeah, the only thing I'd be cautious about is if you're a larger employer and you're administering a lot of FMLA leaves, that you not pick and choose when you're going to require the med cert form, because that, you may get some employees who feel like, why are you making me get one? I know you didn't make so-and-so get one. So I agree with that. If you're a larger employer and you're administering a lot of these, you do need to be careful about being consistent.
We have a question in regards to the necessity to have the employees keep 80 hours of vacation time. Is that strictly a paid FMLA requirement, or does it apply to the CTFMLA as well? And I know it doesn't apply to the federal FMLA, but does it apply to the CTFMLA?
Yes, it does apply to the Connecticut FMLA
as well. So the paid
Whether
FMLA and the CTFMLA required.
Whether the employee goes to the leave authority for wage replacement benefits or not, if we're forcing them to use PTO for unpaid portions of the leave, then they still get to keep the up to 80 hours if they choose.
Right. Keep in mind, it's 2 weeks, very technically, right? So if you have a work schedule that's 35 hours a week and somebody has 2 weeks of PTO, it's technically 70 hours. I just don't want to think I don't think the statute actually says 80 hours, right? It's 2 weeks.
Fair enough. There's a question in regards to the number of employees, how you determine number of employees, whether seasonal workers are included. I think it's the question harps back to the days when we had 75 employees. But in this case, we no longer worry about the seasonal workers because it's everyone is from one up. Is that correct? Or you could expand on that.
Yeah, so I mean, it's one employee or more. And, you know, I'm not aware of a company. I mean, it'd be very rare for an employer to have, I don't know if seasonal employees are specifically addressed in the statute, but it'd be very strange to me if an employer had 0 employees, but a lot of seasonal employees. You know what I mean? Like, so generally an employer who has seasonal employees has at least one regular non-seasonal employee. So I would think, I would, you know, I don't know if it's the employee specifically, the definition of one or more employee specifically addresses a seasonal employee, but my hunch is you would be covered if you had just one seasonal employee.
As the hour approaches, we have a doozy of a question which asks to explain the intersection of workers' comp, CTFMLA, and federal FMLA.
So workers' comp, the Workers' Compensation Act does not have anything in there that specifically says you have to provide an employee a certain amount of time off from work, right? The Workers' Comp Act simply has a statute that says you cannot retaliate against an employee for exercising their rights under the Workers' Compensation Act. And so the standard for determining whether or not you have violated that statute is sort of that burden shifting analysis, similar to what you would apply in a harassment claim or a discrimination claim. You know, if you have a reason for terminating that person's employment that has nothing to do with the workers' compensation leave that they took or the workers' compensation rights that they exercised, then it would be permissible. There's no set amount of time that you have to give under the Workers' Compensation Act. The other laws, the FMLA laws, have actual job protection time off that an employer must provide to employees. And so here's where we see where employers have to make a decision a little bit. You know, Connecticut Supreme Court has held that if an employer terminates an employee pursuant to a neutral absence control policy, right? So there was a case going back many years involving an employer that had a policy that says, if you've been out of work for 1 year, right, no matter what, you've been out of work for 1 year, no matter what, we will terminate your employment. And so an employee was on workers' compensation leave for more than 1 year, past that threshold, the employer terminated their employment, and ultimately the employer prevailed under the Workers' Compensation Act. You know, the Supreme Court found that that was not a violation of the Workers' Comp Act because the employer had a neutral absence control policy. That neutral absence control policy would not apply or would not be effective in mitigating the risk of claims under the ADA, Connecticut Fair Employment Practices Act. So we know under the FMLA, you must give 12 weeks period, job protected, right? But if you had that same policy 1 year, if you're out for 1 year or more, we will terminate your employment period, end of story. And an employee was out for 12 months, has a disability, comes to the employer and says, you know what, I need 12 months in 1 week. And the employer says, I'm sorry, we terminate everybody at the 12-month mark. While that policy is effective under the Workers' Compensation Act, it could not be used or relied upon by the employer to automatically terminate somebody's employment under the ADA or under Connecticut law, because those statutes require that you make exceptions to your policies for somebody that has a disability. So when you say we will give you 12 months, what you've really done is you've established a new floor, right? The baseline is now 12 months. And if somebody needs 12 months in 1 week, for example, you'd have to explore that additional week as a form of reasonable accommodation.
It's a great example of a double-edged sword, a neutral absence
Yes.
control policy.
Yeah. You touched on it earlier, Nick, in terms of how the week is defined. If the statutes say 12 weeks, well, if your work week is 40 hours, say 35 as opposed to 40, do you have to give the equivalent of 12 times 40 or 12 times 35?
12 times 35.
Yeah, whatever the employee's regular work week is what it's all expressed in terms of weeks, not hours.
Okay, fair enough. If the doctor, as an employee on a reduced schedule following surgery and the FMLA is exhausted, do we have to continue to offer time off in accordance with ADA?
Go ahead, Vince, you try.
I think it's the same kind of analysis as there would be that Nick kind of went through, you know, as if the employee needed some additional an additional block of leave. So, you know, if you're talking about it under the ADA or CFEPA, it's that reasonable accommodation analysis. Can you provide that without causing an undue hardship on the company?
We are at 1:56 and the questions, okay. If employer's PTO policy is use it or lose it, an employee retains 80 hours and is out in FMLA when the reset date passes, does the employer have to carry the 80 hours of PTO?
That's a very good question. I've not seen that come up, and I don't think that's addressed. That nuanced situation, I don't know that that's addressed specifically, other than allowing them to retain the 80 hours. I think it's simply.
Yeah, I mean, yeah. Mike, let's assume the scenario. Let's assume the employer is silent on whether it requires employees to substitute or to use their PTO and they're on FMLA. So an employee has, say they have 80 hours of PTO time. They start their leave on November 1st. They apply to the FMLA authority. It's granted. Assume everything runs smoothly. They start getting their paycheck. The employer's got a calendar year PTO. And the employer does not require an employee to use their PTO to supplement their FMLA or to use it at all. It's totally up to the employee as to whether or not they want to do it. And the employer's PTO policy also says very clearly that at the end of the calendar year, it's use it or lose it. And if you don't use it, you lose it. I think they lose it, right? Because I think you're right, Vince. I don't think this is specifically addressed, or at least I haven't seen it. But if the policy is very clear that at the end of the calendar year, whatever time you have left in your PTO bank, if you haven't used it, you lose it. I think that policy stands. I think it's harsh, but it stands.
Interestingly, you may have noticed we have something in the chat room, which in the person indicated have communicated with the state attorney, indicating differently. So it is an interesting question, like you said. Yeah. And further thoughts on that topic, or?
No, I mean, I think we were getting peppered with a lot of questions. I haven't kept track of all of them. There are like 22 new ones I saw.
Yeah.
We will, there will be a recording of this, right, Phillip, that folks can access if they want to go back and listen.
That's correct, exactly. We have time for a couple more, or at least one more. Within the 12-month period, let's say I use my paid medical leave care to take care of my dying aunt for 8 weeks. Now I need 3 months off for my own hip replacement. All my PTO is gone. How many weeks do I have left to use? Just 4 weeks of unpaid CTFMLA?
Yeah, I think in that case, the employee would not have any PTO available to them because they've exhausted it, but they would still have 4 weeks of FMLA available. And so obviously that means 4 weeks of job protected leave. And if they so choose, they can, go to the state and seek and apply for the wage replacement benefits for that same 4 week period of time.
On that note, it's time to call it a day. We thank you both very much, Nick Zaino, Vincent Farisello of Carmody. You've been a tremendous resource for us in this past hour and for many other hours in helping CBIA. We very much appreciate you. As you indicated, this recording will be available for members. And so you'll continue to give them advice in that sense as well. And please feel free to reach out to Nick or Vincent if you have additional questions that you feel will be of assistance to you. On that note, again, on behalf of CBIA, we thank you for joining us and have a pleasant afternoon.